I actually just became a lawyer 3 years ago. So, no, I'm not 26 years old and bald. Most people that are graduating law school are 26. So I just chose to go to law school later in life. But if you have interest, or if you have a career or a thought about doing law, the good thing about being or going through that route is you don't have to know at the beginning what kind of lawyer you want to be. So you can make that decision almost at the end of your path to becoming a lawyer. So step number one, are you guys taking SATs or ACTs? Which when you graduate?
SAT.
Yeah.
SATs? Okay. So you take your SAT, you get into some undergraduate school. Usually it's a 4-year plan. Most lawyer or pre-law students will major in something like political science or history or English. Just something just to get a bachelor's degree from a 4-year university. So let's take, for example, you go to NIU and you declare your major to be history. So after 4 years, you're gonna graduate, you're gonna have this sheet of paper, and really, if you're wanting to become a lawyer, all that sheet of paper is to help you get to the next step, which is to apply for law school. Now this is where it gets crazy. If you have not heard about the Lsat, that's the entrance exam to apply for law schools. That exam is a total mind teaser. You'll have questions like 5 students are sitting at a table. Student A has to sit across from student B and can't be sitting next to student C. So where's student E sitting? And you've got 22 seconds to do all that logic and figure all of that out. Then there's reading comprehension, and then there's logical analysis. You know, if all cats are brown and everything brown poos in the yard, then all cats have to poo in the yard. Is that a logical statement? You have to figure all of that out, and you literally have 22 seconds to do each of those questions. It's not easy, but once you have an LSAT score, that's where you can now start applying to law schools. So if you get through that, and mind you, most people take it 2 or 3 times, because you get to use your highest score. But once you take that LSAT, and you've got a score that's good enough to get into a law school, and I think there's at this time 233 law schools across the country that are accredited, then you can apply. So you have your bachelor's degree from, I think I said NIU, so you have a bachelor's degree from NIU, you've got your LSAT scores, and now you apply to law school. So law school is typically 3 years long. So I did it in 2.5 years because I actually took classes over the summer, because since I wasn't a 20-something, I was like, let me get out of here as fast as I can. So I actually just took classes over the summer and tried to get out. You can also work and go to law school. There's a 4-year plan, and you don't have to take a full load every single semester, and you don't. And then that way, you know, you can still work, you can earn a living, and at the same time, you can still get that law degree. Most of the classes are at night. I will tell you, I went to Chicago Kent, which is best law school in Chicago, and I trained it from Lake in the Hills every single day, went to class, then on the train ride back, I'd study, and then by the time I got home, you know, sleep, eat, do it again the next day. It sucked because I had a few kids, and I didn't see dad for a little while, but again, the idea was, let me get out as fast as I can. So, once you apply to a law school, that's where your first year, and these are the things, I guess what I'm telling you is, what I wish somebody had told me, and I knew before I started law school. So, year number 1, they pick all of your classes. You don't get to pick anything. You do everything, every class, and this is in every law school in, I would say every law school across the country. You take 6 general subjects. Property, so you learn about real estate. Criminal law, you learn about criminal law. You may do constitutional law. You may do what's called civil procedure. So you have to learn the whole thing, and that's usually year 1 in law school. Year 2, you get to start start deciding, well, I really was interested in constitutional law. So maybe I want to be one of those people that goes and works in Washington, D.C. and helps congressmen interpret statutes and things like that. Boring. Maybe I want to do tax law. Why? Because you can make a ton of money. A ton of money. If you're good in numbers, and you got a law degree, because most lawyers, they say suck at math. But I wasn't, by the way, I was really good at math. So if you want to become a tax attorney, usually the most hated profession in America. That's one of your decisions. If you want to practice, like what I thought I was going to do, is I worked in a career for 20 years, owned my own business. I was going to go get the sheet of paper to be a lawyer, and then use that in my own industry, which was debt collections. So maybe the second most hated profession. That way I could file judgments and collect money and just do that. So that was my intention. Well, what happened was I went into a mock trial, which I heard from Coach that you guys actually do. So it was at this law school, and at Kent, our trial team ranks third in the country. Can you tell I'm going to tell Kent a few times today? So Kent was third in the country, and I was like, well, I'm going to go try it. And I walked in, and there was this big courtroom, like a mock courtroom, and everything, the lights went on, and I was like, wow, this is pretty cool. I want to be in a courtroom. I don't want to be in a little cubicle. I don't want to be in a boardroom reading sheets of paper. I want to do this. Well, the easiest way to do that, being in a courtroom, is you do criminal law. So that brings us now to the state's attorney's office. There's two ways you can practice criminal law, right? You can be the prosecutor, which we like to say is on the right side of the law, and then you can be criminal defense. Now, I was talking about money. After tax attorneys, criminal defense attorneys make a ton of money. So you may be interested in that. Say, well, if I'm going to go through 4 years of school and 3 more years of law school, yeah, I need to make some money. So criminal defense is usually a very, very, very beneficial career for some attorneys. Now, I would say 70, 80%, and it is high, just like that big of a number, start out in prosecution. So they start working for different federal agencies or different state entities that enforce the law. So I think I heard Coach say something about an officer you're gonna hear from. So officer goes out, writes a citation, let's use DUI. So they pull somebody over, person's drinking, they run them through some tests, they charge them with DUI. So now once that ticket comes back, they book the individual. Hopefully none of you know about this process, and you're hearing it for the first time. But then you go through this, you go through booking, and then you bond out. So now you have a trial date, right? Now what happens with that ticket is the citation goes to the state's attorney in whatever county you got that citation. So if it was here, obviously it would come to the McHenry County State's Attorney's Office. At that point, really two different parts to our office. Is it a felony? Or is it a misdemeanor? So a felony would be a very serious offense. What defines a felony is it's jailable by more than 1 year. If it's 1 year or more that this person can serve because of this offense, then it's a felony. If it's 365 days or less being the maximum punishment, then that's a misdemeanor. So a DUI, 1 year, that's a misdemeanor. Now, if it's a DUI and you killed somebody, well, now it's aggravated and it becomes a felony. So just to kind of show you how, some criminal offenses could actually fall into both categories. But once it becomes a felony, then at that point, we have a group of attorneys. I want to say in the office there's probably 8 of us now or 8 that handle the felony side and 6 that handle the misdemeanor side, not counting the chiefs as well. So one of the 8 attorneys there, I should say, if it's a drug offense, so possession, controlled substances, delivery, those kind of things are all felonies. So we have specific attorneys that handle nothing but those kind of offenses. So you can even see within one field of law, criminal law, how specific your role could be. You could be, I'm just a drug attorney. I mean, it sounds funny, but that you're the one that's prosecuting any of those drug offenses that are charged within the county. So my group, we handle everything from a traffic ticket all the way up to a battery, DUIs, all are misdemeanors, again, unless there's some aggravating factor. Most of what we get are fights, that's very common, assaults, domestic batteries. So domestic battery has a specific department or a specific attorney and courtroom in our county, unfortunately, because it occurs so much. So that's not a good thing. And so we have specific prosecutors that are trained to bring those that are charged with domestic battery to justice. So those are some of the examples. I think I gave you some examples of felonies, aggravated batteries. You use a gun. You point a gun at somebody, that's a felony, because that person, again, is in fearful life of imminent death or threat of harm. So, yeah, that's kind of how our office is structured. Criminal defense, you could specialize in only DUIs and say, I'm gonna do criminal law, I'm gonna do criminal defense, and I'm only gonna defend DUIs. In fact, there's an attorney out there who calls himself the DUI guy. Like, that's his website, that's his whole thing. I'm not telling you this so that and if you have to deal with that, I'm not doing any advertising for him, certainly. But you can see how specific, again, your legal option can be, even within one field of law. My, I guess, path was a little different. I always wanted to be a lawyer, but I again decided late in life. So if that's what you want to do, it's certainly something you can do. I went to my undergrad, I just decided to work a little bit, and then I was like, I should do this. And so I took the Lsat actually 3 times. Some people say that was like crazy. But thankfully my score got better with each time I took it, so there you go. I guess I should say I enjoy this more than anything else. I really love going to trial. Trials are really, really cool. You're in a courtroom, you're talking to not this many people, but 12 people in a box, and it's your job to persuade them that the defendant committed this crime. In criminal law, unlike in civil law, which I'll get to in a second, but that's a boring law, so I don't talk about it much. But in the criminal law, the burden is on the state. We, the prosecutor, have to prove our case, and I'm sure you've heard it on TV, beyond a reasonable doubt. So the defendant, the criminal defense attorney, they don't even have to put a case on. Like 9 times out of 10, the defendant won't even take the stand. If they're a smart defense attorney, they won't even put them there because we'll get to cross-examine them. You guys know about that whole trial process, like bench trials versus jury trials? No? Okay, well, so if you've heard the term bench trial, it's just a trial, except there's no jury, it's a judge. So you're just in front of one judge, and we still have the same burden. We have to prove it beyond a reasonable doubt, and the defense side, again, has no burden at all. So that's only in front of a judge. In a jury trial, there's 12 jurors and 1 alternate that will sit there in case something happens to one of the other 12 jurors. We don't want to have to redo the whole trial, so that person will just go in and fill in when it's time to deliberate. So there's a bench trial, there's a jury trial, burden's the same. We have to meet it, we being the prosecution, the state's attorney's office is really what's gonna happen in the county level. At the state level, you have AG's office. You have federal levels as well. So those prosecuting, if you commit a federal crime in McHenry County, it won't be the state's attorney that prosecutes it. They'll bring in a federal attorney. You'll usually have them from the United States Attorney's offices in the region, and say, hey, this person lives in your district, not county, they call them districts, and so you prosecute them. Back to what I was saying, I had my little moment in law school, and now I get to do it almost every Monday. It's really cool, except for code. Code screwed everything up. Yeah, nobody wanted to come to courtrooms, nobody wanted to be a juror, and I don't blame them, right? You're sitting 2-3 feet away from 12 or 13 people that you don't know, and then you gotta go in one room and you gotta deliberate. So I get it. And so for about, I think, 6 months or so, there were really no trials popping up at all. And no felonies, no misdemeanors. Everything was just get a continuance, get a continuance. Well, that's boring. I could have done that and done civil law, like real estate law or something boring like that. So we're excited that, now with the number of vaccinations and all that, thankfully, trials are back up and running. So usually every Monday, my guys, or usually every Thursday and Friday, we'll have a little powwow and say, okay, what's going on Monday? And yeah, sometimes, like the life of a prosecutor, you have so many cases, you can't necessarily prepare for every single one of them. So you kind of get a feel from the defense side, are they gonna go to trial, are they not? And if they are, you start to prepare. So what does that mean? Talk to witnesses, bring those people in, especially in a domestic battery. And sometimes those are hard because your victim has fallen back in love. And so they don't wanna talk to us anymore. And they don't wanna be part of the prosecution. Well, you don't get that luxury, right? You called the police that night, police got involved, citations were issued, and now they're in the hands of the state's attorney's office. So sometimes those are hard cases to prove. I mean, ask yourselves, right? If you were sitting in a group of 12 jurors, and here's this domestic battery case, and the state's attorney's obligation is to prove that this individual battered this individual and that they were in some sort of familial relationship or dating relationship when he did it. And then there's no victim. She doesn't even come to trial. Sometimes jurors will be like, no, and we have to prove our case with the 911 call, with the officer's report, with photographs. Sometimes, again, jurors may say, well, if the victim's not here, why even bother? So you have a struggle sometimes in proving you're meeting that beyond a reasonable doubt threshold. DUIs. So DUIs are, I guess, those boil down 9 times out of 10 to the squad video. You hear some of my DUI attorneys complain, well, the jury always wants to see the guy stumbling out of the car, like the Hollywood drunk, right? So when the guy isn't doing that, jury's like, I don't know, maybe he's, because of course the person didn't blow or didn't validate whether or not they were over a certain amount for the alcohol. So those become tough cases to prove. And again, the defendant has no burden. They don't have to say anything. So you're probably scratching your head going, well, shoot, let's go be defense attorneys and just sit there and watch the whole thing happen. If they meet it, they meet it. If they don't, they don't. Well, no, you do have to try and defend your guys a lot of times. The cross-examinations that happen, preparing for those, that's usually the bulk of your work right there. So that's a jury trial, that's a bench trial. I think if I remember my outline, and I'm picturing it in my head here, that's usually the last kind of thing I talk about. Any questions? You got it.
I always like to ask this question, when you have the jury members in there, when you're picking a jury, are there any specific questions that you like to ask in that process to kind of eliminate people and choose different people?
So really good question. So that's called voir dire, Latin term or French term, I think, as well. I think it's French. So voir dire is your jury selection. Every Monday, about 60, 70 of McHenry County's finest residents had a card sent to them that says, you better show up at the McHenry County Courthouse for jury duty. So then, let's say I'm doing a DUI. So if I'm doing a DUI, they'll bring in 25 people that we get to ask questions to. So that process is very interesting because I did mock trial in law school, and you didn't do voir dire. So really, when you become a lawyer, you've never learned voir dire until you actually do it. So my first trial was an aggravated battery. This guy sucker punched this other guy and knocked 3 teeth out of this guy's mouth. And they were stuck in his retainer, so these pictures were horrific. And he sucker punched him. So I was like, that's a really cowardly thing to do, right? You know, love this, ladies, they were fighting over a gun. Of course. The teeth are hanging in the mouth. I gotta bring jurors in and start asking questions, and my first chair, because I just got put on this trial, looked at me and said, you wanna handle this first panel? And I realized at that moment, I've never done voir dire. So, no, let me watch you do it. And so the first question we usually ask people are things like, especially in today's day and age, do you have any animosity towards the police? You know, do you just think police are out to get residents of every community? And that's one of the newest questions that we've had to come up with just because of recent events. In a DUI, I'll ask everyone, do you drink? Right? Because if you're not a drinker and you watch this video, can you relate? You know, can you say, well, you know, he's not, he did his steps, or he did his one leg stand, he wobbled, but that happens to me when I'm not drunk. So, or when I haven't had any alcohol. So I usually ask questions like that. Other questions we ask you are, do you know anyone, right? You can't have a bias of any kind. Sometimes a juror will say, and this is classic, the defense attorney represented me in my DUI. And you're like, oh, well, you can't be on the jury then, okay? So those are, when we go through the process of what's called a RAC 14, which is the newest way they do jury selection, the judge asks questions of the juror pool, and he'll ask them questions like, what's your name? You don't have to tell us where you live. How many kids do you have? And what do they do for a living? And what do you do for a living? Things like that. And then we get to ask our own individual questions. I gave you examples of that. And then the defense attorney gets to ask their questions. And they'll say things like this. Oh, and we like to sneak in questions, by the way. One good one is, so, sir, if the state were to prove our case beyond a reasonable doubt, what would your verdict be, right? And then the juror's like, well, they're gonna prove it beyond a reasonable doubt. So they'll say guilty, right? And we may ask that of 4 or 5 different potential jurors just to hear the word guilty in the courtroom. It's a little trick that we do, right? And of course, defense attorneys may come back and say things like, so now, if the state does not prove their case beyond a reasonable doubt, what's your verdict gonna be? And you'll hear the not guilty. Well, if they don't meet their burden, not guilty. And then they'll ask questions like, if the defendant doesn't testify, especially in a domestic battery, right? Some people say, well, I wanna hear from him. And if I don't hear from him, you know, clearly he's hiding something. So the defense, if you're a defense attorney, you wanna make sure there's no bias there. So you'll say things like, look, if you don't hear from my guy, are you gonna have a problem with that? And if somebody says, well, yeah, I wanna hear from that guy, when it's time to go up to the judge, usually the judge will start something like this. He'll say, all right, these 4 people, state, are you okay with 1, 2, 3, and 4? And we'll say, yes. And then the defense may say, well, get rid of number 3. We don't like number 3. So now it'll come back to us and the judge will say, all right, state, 1, 2, 4, and 5. Are you okay with that group? If we say, well, judge, we don't like 5, because 5 said that she hates the police, so you gotta kick her off, judge, and that's for cause. So you'll go through that process until you end up with 12. Right? Well, and then 1 altercation. But that's 1 year, you get to ask any question you want, by the way. The judge will restrict you from getting too personal, because these jurors, don't forget, they're talking in front of a group of 12 or 20 other people. So we may even ask them, have you had a DUI? And they'll say, well, yeah, I've had a DUI. And we then will ask, okay, did it happen here in McHenry County? Well, no, mine was in Cook. Okay, you don't have to tell us what happened, and we don't really need to get into that, but do you think you were treated fairly? We just may ask that. And if the person said, yeah, I was treated fairly, then you can ask them a question like, well, did you take it to trial, or did you plead it out? Now, the defense wants to know that. Why? Because if I'm a defense attorney, I'm gonna say to myself, well, that juror over there is gonna look at my guy and say, hey, I pled mine out, plea yours out. You should plea yours out. And if you're not, I'm gonna find you guilty anyway. So that's how the defense may kind of pry through and figure out who may be biased to their client. But that's usually one. Any others?
How do you get picked?
How do you get picked?
Yeah.
So when the judge goes over the group of 4, if both sides agree, juror numbers 1, 2, 3, and 5 are in, then that's the first 4. And then he'll turn to the defendant's attorney and say, all right, number 6, 7, 8, and 9. Are you okay with that group? And then they'll look over at us, yeah, we're fine with that, all right? That becomes 8 members. At the end of that selection, the judge will look at the sheet, and he'll, talk to the jurors and say, all right, juror numbers 1, 4, and 5, thank you, but you're excused. A lot of times, let's say you got family that's police officers, right? If you're a defense attorney, you'll ask a question like, all right, listen, Mr. Smith, your family, you've got 2 uncles that are officers, don't you think like the testimony of a police officer would you consider that better than the testimony of anyone else? And if the person says yes, well, you're not going to do that person on the jury, right? Well, yeah, I believe cops more. Well, now you're biased to the defense, so you won't be selected. So the judge will go through the selection until there's 12, and then you start the trial. Opening statements, and fire off from there. If you don't get picked, here's the good news, you get paid just as much as those that did get picked. And it's not a lot. So. But yeah, but you don't have to spend your whole day there, so. There's that. Questions? Yes?
What would you say is a good base score to try to get into law school with the Lsat?
Very good question. So if you, so the score system is 180 being the perfect score, and no one gets that. It's not like the SAT where you can get the 1600s. No one can get the 180. So if you score anything over 160, you are top 20% law schools. Anything between 142 to 160, you can still get into a law school. So I scored a 158, couldn't get to the 160, but it didn't matter. I wasn't gonna, just come out. I wasn't gonna go to like one of these elite schools. So and I needed something. So, yeah.
What degree did you get in your first 4 years?
Psychology. Yeah, I started out as a bio major because everyone says that they're excited. I was like, oh, I think I'm gonna be a doctor, and then I hated blood. And you can't be a doctor. Yeah, like I can't even give blood. Like literally, I see it and I'm like, so I couldn't be a doctor. But I had taken calc, I had taken all these maths, I had taken all these sciences, and so I got a bachelor's of science in psychology. Yeah.
What college did you go to?
University of Houston. Cougars. Yeah.
What would happen if somebody got that card to go to the jury duty and then didn't show up?
Okay, so very good question. How can I avoid jury duty? So usually the first time they send you a letter, a very stern letter that says, listen, it's your duty you know, and you've not done this, I think they give you a reprieve, like, they can't keep making you do jury duty every 3 months and every year, whatever. So you get a reprieve. If you've done it once, you won't be sent a letter for another 2 years. But to answer your question, they usually send you a very stern letter that says you need to appear, or you'll be held in indirect criminal contempt of court. They'll slap you on the hand, basically. Yep. Any others? Anyone have interest in going to law school or becoming a lawyer? Nice. Nice. Good. Yeah, I mean, you know, the running joke is, what do you call 1,000 lawyers at the bottom of the sea? A good start. So our answer is, well, we'll just put another 1,000 out there then. Yeah, I mean, and again, it doesn't matter. Like I said, you can wait until your second or third year in law and say, all right, I think I wanna go and work for a congressman. And then that's like really, if you're interested in that, it can be so rewarding. The problem is, you literally are working almost 20 hours a day. You're in think tanks, you're meeting large groups of other lawyers that their brains are wired exactly like yours. A lot of times you are at the pinnacle of new law, which is really, really exciting for some people. You know, that, listen, we're the ones writing this, that's gonna impact, you know, generations of people, because whatever law you write or however you word it, I have a very interesting case, and then I'm almost at the end, right, Coach?
Yeah, what are we at, 8:20, right? Or 9:10, sorry, 9:10. 8:20, that's a long time ago. I'm screwed up.
I just wanna make sure I'm
Yeah, 9:10, so we got 10 minutes.
So an interesting case to the point of how words or statutes are written. We have a case here in McHenry, and again, it's okay for me to talk about it, it's public, but there's cases that are very, very stringent on what the wording of the law is. So there's privileges, for example, attorney-client privilege, clergy-penitent privilege. So a lot of times you're interpreting just that. So I talked about bench trials. So in a bench trial, what the defense thinks is the way the law is worded, there's no way the state's gonna meet their burden. All I have to convince this judge, just the judge, not the jury, but just this judge. Judge, you see the words in this law? They didn't prove that every single one of these things happened. And they start breaking the words out and breaking the words out. So you spend a lot of time saying, okay, statutory, how do I interpret this? What does this mean? So, some interesting cases out there. Yes?
Have you ever like dealt with a case or like gone to a case that's been like the state Supreme Court?
Okay, so that's a good question about kind of what happens through the process after it goes to trial. So when we have a trial here at the state level, because even though we represent just McHenry County, when we answer ready, it's the people of the state of Illinois. It's just, so we represent the state. Now, if the defense appeals a ruling, a jury verdict, and it goes to the appellate level, our district is in Elgin. The appeals court is 3 judges. You don't have a jury. You have 3 judges, and then you have the appellate prosecutors going up against appellate defense attorneys. And 9 times out of 10, it's statutory interpretation, right? This judge down there interpreted this way, and he was wrong. And we are appealing, and we want you 3 judges to see it our way. It also may come down to, is it constitutional? Is the law that these people are trying to enforce constitutional? And they'll appeal it there. So if the appellate court says, nope, we're agreeing with the McHenry County judge, he did the right thing, she did the right thing, so we're not gonna reverse the verdict, then the defense has the opportunity to appeal to the Supreme Court. So it has to go through that process. And don't forget, the Supreme Court, I don't know if you know this, they pick. They don't take every case. They get to pick which one, you know, this is worth listening to. This is, this is a case where a lot of people are gonna be impacted by this. Obamacare, I don't know if you guys are too young to remember when that first came out. That was a big deal, so you had states saying, no, it's not allowed, that's not allowed, you're infringing on our privacy, and the insurance companies were like, oh, this is gonna destroy our industry, it's gonna ruin our economy, and all of these things. And then you got so now the Supreme Court was like, well, we gotta listen to this. So usually, if a case climbs all the way up, especially a case that's gonna impact so many people, the Supreme Court with Roe versus Wade, cases that were real big. But I don't know if you just noticed 2 days ago, the state of Texas, which is where I'm from, don't hold that against me, I'm proud Texan. No belt buckle, but I don't know how they do that. They just passed a law saying after 6 weeks, you can't have an abortion. The ladies can't have an abortion after 6 weeks in the state of Texas, today, 2021. Okay, so think about that. And the Supreme Court said, well, we're not gonna listen to that. We don't wanna listen to it. So that kind of shocked everybody. And, the passing of a very liberal justice, Ruth Bader Ginsburg, that shifted the court. So now people are saying, well, look, it's happening because of this. They're not listening to these important cases.
Can you share like one of the most bizarre, exciting cases you've had so far? Something
Sure.
that just
Sure, so, we had an individual who claimed that he was a vet, and that he was on the metro train, and he asked for a discount. He hasn't even noticed that, so he asked for a discount. The conductor said, just show me your military card, I'd be happy to give you a discount. The guy said, no, I don't have it. He goes, well, if you don't have it, I mean, I can't really give you the discount. And the guy exploded. Huge rant, I'm gonna do this to you, I'm gonna do that to you, threatening, doesn't do anything to the conductor. The conductor then walks by him. The guy shows him a screenshot of his phone where it says he's a painter and his name is like Patriot Painting. Yeah. And he's showing this to the conductor saying, look, that's my website. And you doubted me. And the guy's like, what are you talking about? I just asked for a military ID, this and that. Well, he pushes him. Well, no, I'm sorry, he takes a step towards him. Well, once the guy takes a step towards him, the conductor's like, you know what, screw this. Pop. And the vet was down. Well, his two buddies jump up and all of this, and then they come and separate them. Well, now you got Metro involved, their lawyers are very concerned about what's gonna happen to this employee, and you got a lot of stuff going on. And we bring this guy in to talk to him for the first time. We realize there's no way he can be a vet. Like, there's no way the story he's telling us is true that he had served in the military. He's talking about the Vietnam War. He would have been like 7. So we're like, how are you even saying this? And me and my co-counsel at the time, and this was literally 2 or 3 months into my legal career, are looking at each other like, this guy is full of shit.
No, you're good.
I'm sorry, no, that-
You're fine, you're good.
Edit that.
Yeah.
Edit that. This guy is overly, we're not gonna prosecute this, there's no way we're gonna prosecute this. Well, he's passionate, oh, no, this is what happened, and this, and I'm a vet, and, you know, Buck Sergeant, he kept calling himself. We're like, whatever. My co-counsel and I go into the trial saying against this guy, well, he did hit him, right, he did hit him. So it's a battery. We're gonna have to go to trial because we have this noxious victim, and, I mean, again, he did get it. So, imagine now you're going into this trial, and all you've been taught was win, 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 and you don't wanna win this one. You really need to lose this case, because it's so stupid, and this guy is clearly lying, instigated this whole thing. And so we feel, again, in the prosecutor's guide, can you dismiss it outright? Sometimes we do. Sometimes we just say, you know what, screw that case. We're not gonna take that to trial. In this case, you have an obnoxious victim, so okay, let's go. We put him on the stand, first thing he does is he takes this hat, okay, it's like USS whatever, and he puts it like so that everyone can see. And then they ask, my first question is, sir, can you state your name and spell your last name for the record? And he starts, Master Sergeant Antonio Vincenze Smith, 8 names. But my friends call me Sarge. Well, I mean, I don't have too much time to talk about this, but he made such an absolute fool of himself. The absolute fool of himself, that the judge was like, no, not guilty. So we looked over at the defendant, and the defendant, literally my counsel and I are thinking to ourselves, wow, that sometimes, again, justice can rear its ugly head in a very strange way.
Was he really a vet?
No.
Yeah.
No, in fact, we thought about prosecuting him for stolen valor.
Right? Huh?
Yeah, we couldn't prove he was gaining anything though,
Okay.
but, yeah. But, yeah, we don't have very many murders, so, you
Yeah.
know, stay that way.
Yeah. Well, thank you. Thanks for coming in again.